what regards political aspects of modern life, we are focused on giving to Romanian students, to Romanian usual citizens, and also to the public media, an insight about what should be a normal government, and the government focused on helping citizens. About today's conference, I will speak shortly, because every one of you has probably already seen the materials that you have, and you'll find there briefly described all the topics and themes we are going to try to cover today. The conference will have two panels, two main panels, each one of them focused on different topics. The first of them will be the judicial reform, as seen from the European Commission's cooperation mechanism for verification. And the second panel will deal with the more sensitive matter, that of national sovereignty in the European context.
Accomplishment of the law is brought by the possibility to subpoena now parties in both civil and also some criminal cases by email, fax or telephone. As you know, our civil procedure code and criminal procedure code had only the possibility to subpoena parties by post. So now we adapted to modern society requirements. In order to remove cases from the competence of the courts, there is also the possibility now, as you've heard probably, to divorce in front of a public notary or in front of a civil servant. So the divorce is no longer mentioned as to be in the competence of the judge. Following the EC report in 2000, July 2000, the lawmaker changed the competence of the High Court of Justice to make it more look as a court of cassation rather than a third degree.
In the Schengen area, Romania must successfully go through an evaluation process consisting of several stages, of which the most important stage are the Schengen evaluation visits, verifying the stage of the Schengen acquis implementation. On January the 20th, 2011, the Schengen Evaluation Working Group adopted the Schengen Evaluation Report in the field of CSIRE for Romania, drafted after the last evaluation mission, which took place in Romania during December 2010. Thus, Romania successfully concluded the Schengen evaluation process. However, not all EU countries feel that Romania is ready for accession. Such is the position of the French Interior Minister, his German counterpart, and as well as the French European Affairs Minister, who declared that it would be premature to let Bulgaria and Romania join at this moment. Because we're talking about the cooperation and verification mechanism, just a brief declaration about the impact it has on the Schengen accession. The last CVM report dated July 2010 pointed to a lack of efficiency in the judicial process and the inconsistency in court rulings as the fundamental weakness of the Romanian judicial system. It also cautioned against the insufficient political commitment to support the reform progress and warned against little movement made in high-level corruption cases.
Subiectul Schengen, ați văzut, este în presă, e prezentat în ziare, avem scrisori comune, avem o grămadă de lucruri. Ce să vă propun astăzi, am să vă fiu foarte scurt, 5 minute. Vreau să vă imaginați că sunteți în Consiliul Uniunii Europene, cu ministru, că aveți o discuție o bilaterală cu președinția Consiliului Europene și președinția Consiliului Europene vă spune următoarea chestie. Două state se opun ca România, sau se opun în acest moment ca România să adere la spațiul Schengen. Putem să punem sau nu putem să punem subiectul pe agenda? Sau putem să vă gândiți să acceptați un roadmap care să fie legat de MCV prin aderarea la Schengen. Și se presupune că ministrul va întreba pe voi ce părere aveți. Întrebarea mea pentru noastră este aceeași care a pusă și pe lista astăzi. Este sau nu este discriminare? Suntem sau nu suntem discriminați? Și dacă da, cine discriminează?
For member, you are equally free in rights and obligations. Clauza de verificare și monitorizare este o excepție de la normele care s-au aplicat celorlalte state la momentul aderării. Pachetul de aderenți din 2004. Deci, e prima excepție. Al doilea element. Reacțiile lui Sarkozy, în primul rând, și reacțiile establishmentului francez au fost, în faza inițială, politically motivated, never referring to any breaches or criterias, au fost destinate agendei interne din Franța, pentru că Roma issue, it's a highly juicy issue for Monsieur Sarkozy, și acest lucru trebuie respins. Orice discriminare ethnically based should be rejected. Este un criteriu fundamental. De aceea, eu nu sunt deloc un fan al președintelui Băsescu, spun dimpotrivă. Dar în această poveste cu Schengen, Sarkozy este la fel de vinovat ca și Traian Băsescu. Pentru că, până la urmă, comportamentul și limbajul și acțiunile celor doi au produs efecte similare. Și ultimul lucru, legea și sistemul judiciar din țările Uniunii Europene, dacă acolo este considerat bun și funcțional, should be also implemented in my country too. While the prosecutors to have an over-dimensioned role, and in Germany or France or others, the prosecutors to be just one part of the judiciary and not the most important one. Why the secret services to be so omnipotent in Romania and the world tapings to become a daily business for everybody and everybody to be targeted? Is this democracy or not? Regulile care sunt acolo trebuie să fie reguli și aici. Ultima constatare, și sunt de acord cu dumneavoastră, în sistemul de gestionare a frontierelor din România există corupție. Acesta este un factor major de îngrijorare și dacă mă întrebați de ce, pentru că intrând în sistemul Schengen, ai acces la informații clasificate despre fluxuri criminale, despre acțiuni criminale care vizează România sau alte țări membre ale Uniunii Europene, le împărtășești cu ceilalți membri și acest mecanism trebuie să fie highly reliable. Niciun stat membru să nu se teamă că informații filiere care trec spre România și din România spre alții să primească în avans informația de îndată ce a devenit accesibilă și să scape controlului celorlalți. Este un mecanism de încredere maxim din care România, la care România, din păcate, nu s-a calificat, mai ales prin dezvăluirile recente. Dar asta nu înseamnă că Sarkozy a dreptate. Asta nu înseamnă că CFM-ul este corect și democratic. Sunt lucruri diferite. And before blaming any politician, there are also some exceptions. And we should first look to the judicial system, how it works in other countries, how should be properly implemented in our own country, and then to fit and to match with the EU expectations.
Judicial corruption, judicial ethics. This is a series of issues that we deal with on a daily basis in the United States. So I guess one thing you might be wondering is, so what? Who cares what the American experience with judicial reform is? Well, the answer to that question, I think, is not that the United States has any special set of answers that everybody has to follow to get it right. We're still struggling to get it right in the United States as well. The reason I think the American experience might be instructive to reformers in Romania is because we're dealing with the same sorts of problems and we're considering the same sorts of solutions. And I hope that the American experience, the shared experience that both of our countries have with these issues will be informative to us both as we both go forward down this road. I'd like to briefly focus on three issues today concerning the appointment of judges, how do judges become judges in the United States, the rules governing conflicts of interest and ethics and corruption, how do we prevent judges from becoming bad judges, and then third, the rules concerning discipline or removal from office. What are the consequences if a judge fails to live up to the highest ethical standards? My comments are basically going to focus on two critical values that I think keep coming up and keep informing each of these separate areas. And those values are first, accountability, and second, transparency. Let me explain briefly what I mean by that. By transparency, I mean ultimately that the political branches and the judicial branches' essential decisions that affect the lives of litigants, that affect the lives of ordinary citizens, are done in the daylight, so that the public is able to observe what is going on and ultimately make an informed decision as voters in a democracy, in a republic, what the proper outcome should be in the next election. By accountability, and you can see that accountability is very closely tied to the idea of transparency. We have transparency so that accountability can take place. By that, I mean, if judges make bad decisions, if they're corrupt, if they're unethical, if politicians make bad decisions with respect to judges, right, if they put bad judges on the bench, or if they fail to discipline judges who are doing an unethical job, then there's an opportunity for voters to hold those from outside interference. The idea is to create judicial independence, so that judges have the space they need to decide controversial cases the way the law requires those cases to be decided. Right? So we have a couple of protections that insulate judges from outside pressures. Their salaries, for instance, are fixed and cannot be reduced. In addition, they hold their office work. Yeah, maybe that's a pretty good idea, right? Well, our judges think so too. In addition, they hold their offices for life tenure. Actually, the Constitution says they continue to be a judge as long as they exhibit good behavior. Right. So impeachment is the only method we have for removing judges who fall short of the legal standards. So what are those legal standards, and how do we ensure that judges live up to them? Well, one critical way of ensuring the highest possible legal standards are followed by our judges is, once again, transparency. So judges are required every year to file financial disclosure forms that reveal information about the stocks they own, the banks in which they hold accounts. And the idea is the public should have access to this information so that lawyers who are representing clients and the clients themselves can know whether the judge who's hearing their case is likely to be biased or not, right? If you're Microsoft, or if you're suing Microsoft, and the judge has $1 million worth of Microsoft stock, it looks a little fishy, right? And so we have mechanisms in place that require judges to not participate in cases in which they have a financial interest. The standard is actually not just that. If you are biased, you cannot participate. The standard is actually even stronger than that. The standard is, if there's an appearance of bias, right? If a reasonable person could conceivably believe that the judge might have partiality for a party, then the judge by law is required to remove himself from the case.